Hi everyone, welcome back. So this is where we got to last time. This is where I left you, was looking at Page and Smith and summarising the distinction between primary and secondary victims. Now, one of the areas where primary and secondary victim, that distinction that's been made in Page, has proved problematic is in relation to rescuers. So those who seek to assist and save individuals in an accident or injured in an accident will not always be exposed to a risk of personal harm, but but they are not also necessarily considered as mere bystanders. So one of the cases that has addressed this issue in terms of what rescuers should be considered is that of White and Chief Constable of South Yorkshire. So this concerned police officers who were policing the Hillsborough disaster, and they sued for PTSD. And they argued that as rescuers and employers of the police, they should be considered as primary victims. Now, the claimants were 4 police officers, and they were involved in the aftermath, as I've said, of Hillsborough. And their argument was that rescuers may be primary victims if they were exposed to physical danger or believed that they would be exposed to physical danger. Now, this argument was initially successful in the Court of Appeal, and that was at the case of Frost. However, the decision was reversed in the House of Lords. They held that police officers were secondary victims and they were not within the range of foreseeable physical injury, that the public would have been outraged. So there was a bit of a policy decision being made there. And if family and friends can't recover damages, then the police can't recover either. And the judgment leaves in disarray a number of issues which had previously appeared to be settled, but the position of rescuers now appears to be uncertain because they're now no longer automatically classified as primary victims. So up until the case of White, the belief was that rescuers were and could recover damages as primary victims. Now, whilst that's a general sweeping precedent across the fact of police officers predominantly being secondary victims in the context of psychiatric injury, police officers may still be found on the facts to be primary victims, but it is dependent on the facts of each case. So, for example, in Donarchi, the claimant had been asked to work undercover, and the surveillance equipment he was asked to use was faulty, and it required him to put himself at risk repeatedly to maintain it, which resulted in a stress disorder and also resulted in him having a stroke. It was held that there was a direct line of causation between the known faults in the equipment and the failure to operate a safe system of work linked to the stroke that he had. So he was obviously very stressed. His blood pressure had gone up because of the failure to be able to operate that equipment, which was known to be faulty. The court should have considered whether the claimant was a primary or secondary victim. He was a primary victim and the injury was foreseeable and the appeal was allowed. So at first instance, his claim was refused, but on appeal, he was successful because the court found that he was a primary victim and his injury was foreseeable in terms of the equipment that he was being asked to use and the known fault there was with that equipment. So whilst White still stands, on the facts, police officers can be found to be primary victims. Now, still sticking with that primary and secondary victims distinction, in Greaves and Everard in 2007, Page and Smith was distinguished by the House of Lords. So with Greaves, Mr. Greaves, he had two employers between 1961 and 1964, and 1964 and 1969, and during which both sets of this employment, he was negligently exposed to asbestos dust. He had an X-ray in 2000, and he was told he had developed something called pleural plaque. Now, pleural plaque are the areas of fibrous thickening of the pleural membrane. He didn't have any symptoms, but there was, following the X-ray, a sign of asbestos fibers, and asbestos fibers can cause fatal diseases, examples of which you have on your screen there. And Mr. Greaves sought damages, alleging that he'd been obviously negligently exposed to that asbestos in his working life, and that his development of this pleural plaque had arisen because he'd ingested the asbestos as he'd been at work. Now, the court held that pleural plaque in themselves, or pleural plaques in themselves, are not damage, which confounds a course of action. They're not a disease, and they're not an impairment of a physical condition. However, when told about pleural plaque and having pleural plaque, Mr. Greaves develops a clinical depression, which is a recognised psychiatric illness. So the question then on appeal to the House of Lords was whether the defendants owed Mr. Greaves a duty of care in respect of the psychiatric injury caused by his anxiety at the risk of his future illness. So if you recall, pleural plaques have been found or have been known to cause fatal diseases. And of course, Mr. Greaves had been informed that he was at risk of something turning into a fatal illness for him. And the House of Lords held, so the Law Lords dismissing his claim, held that it was not reasonably foreseeable that the creation of a risk of asbestos, of an asbestos-related disease, would cause psychiatric injury to a person of reasonable fortitude. So Mr. Greaves had relied on Page and Smith, namely that where there was a physical injury and that physical injury was foreseeable as a result of an event, then any consequential psychiatric injury was compensatable. But the Law Lords disagreed, saying that what was foreseeable, i.e. that he would contract an asbestos-related disease, had not occurred. So he'd been found to have pleural plaque, but it had not yet developed into an asbestos-related disease, which he had been told could potentially be fatal. The Law Lords found that his injury was caused by the worry that a fatal asbestos-related disease might occur, and this was not on the same principle as Page. Counsel for Mr. Greaves argued Page and Smith, so it was not necessary to foresee psychiatric injury as long as physical injury was foreseeable. And Lord Hoffman said the following: in the present case, the foreseeable event was that the claimant would contract an asbestos-related disease. If that event occurred, it would no doubt cause psychiatric as well as physical injury, but the event had not occurred. The psychiatric injury had been caused by apprehension that the event may occur. The creation of such a risk is not in itself actionable. And I think it would be an unwarranted extension of the principle in Page and Smith to apply it to psychiatric injury caused by the apprehension of the possibility of an unfavourable event, which had not actually happened. So what they're saying there was the psychiatric injury was caused by the worry that he could potentially, the pleural plaque could potentially turn into an asbestos-related disease. But that had not actually happened as yet. Now, the rationale for not allowing the claim was that if Page and Smith were given a wide interpretation, and that was the interpretation that was sought by Mr. Greaves, that psychiatric injury caused by the apprehension of an illness related to exposure to asbestos, maybe radiation or contaminated food, would become actionable without any physical injury. So think back to what we said, or what I said in the very beginning, in terms of opening the floodgates to this kind of area. This is another example of how the courts apply or take quite a restrictive approach, so they don't potentially open those floodgates in terms of actionable challenges or actionable claims in psychiatric injury. And the court said that this would be an extension to the principle to cases uncontemplated by the House of Lords in Page and Smith. Now, Mr. Greaves' appeal, as well as the others that also appealed, were dismissed. However, it's worth noting that Lord Hope took a slightly different approach to the majority. So he went on to say that the category of primary victim in Page was restricted to people involved in an accident or its immediate aftermath, where psychiatric injury was caused by a single stressful event. No such event existed here. The case lacked the immediacy of Page. Mr. Greaves' illness was not an immediate response to a sudden and alarming incident. He was exposed to asbestos for 8 years. His depression did not occur until 20 years later. So whilst Lord Hope took a different approach, the outcome essentially was still the same. He was focusing on immediate aftermath, whereas the other law lords were focusing on the notion of Page and Smith in terms of physical injury. Lord Hope went on that his psychiatric injury resulted from information given by his doctor rather than his employer's actions. So again, that restriction is still being made here, but Lord Hope looked at the definition and what concerned immediate aftermath instead of that primary and secondary victim distinction made in Page and Smith. So that takes us back then to what immediate aftermath looks like post Alcock. So if you remember, before Alcock was decided, you had McLaughlin, where Mrs. McLaughlin was able to recover damages in terms of seeing her family members in the hospital covered in dirt and blood. In the case of Janesh, you've got a claimant's husband who was injured. She went to the hospital. She saw him at the hospital. She was psychologically affected. And on appeal, it was found that the driver of the vehicle that had crashed into her husband owed her a duty of care and was liable for negligence, which caused her nervous shock. You've got the case of Ravenscroft, which was doubted in Alcock, and subsequently following Alcock, the decision was reversed. So you had the claimant who didn't witness the accident, but was told about an accident and obviously saw what had happened, the injuries, etc. I think they were to her son, and she saw them in hospital. And the mother, as the claimant, was allowed to recover damages at the first instance, and on the basis that her son had died in very distressing circumstances, although to emphasize she hadn't witnessed those circumstances. However, the correctness of this decision was doubted in Alcock, and that decision at first instance was subsequently reversed on appeal. And the same also went for Havacan, where the claimant's son was killed in a road traffic crash. And 3 hours later, after he'd gone to the police station, the claimant then saw his dead son in the mortuary. And at first instance, he was allowed to recover after claiming he suffered from depression from seeing that sight. First instance, he was allowed to recover. However, following Alcock, that the decision of that was also challenged in terms of it being correct. So what you've got before Alcock was decided in terms of immediate aftermath McLaughlin, Janesk, Ravenscroft, and Heathercon all provide an extension of recovery beyond immediate aftermath as we now know it. So McLaughlin set down immediate aftermath to be immediately after an accident, and Janesh, Ravenscroft, and Heathercon kind of stretched the boundaries of what immediately after an accident would look like. However, cases post-Alcock have taken much more of a restrictive approach. So in Taylor, the plaintiff's husband had suffered a heart attack at work, and he soon died in the defendant's hospital. The plaintiff went to hospital within an hour, was told of his death by a doctor after 20 minutes, about 20 minutes, after her arrival. She was shocked and distressed. She identified the body at the mortuary. However, the defendant hospital had been treating him for many months and had negligently failed to diagnose or treat his serious heart disease. Her claim failed because it did not fall within the immediate aftermath principle, as her husband's body bore no signs of any violent injury. The death was instead considered to be the final consequence of negligence by the defendant hospital over a course of many months. Got the case of Taylorson, again showing the restrictive post-Alcock approach. A 14-year-old boy had died 3 days after he'd been crushed by a reversing vehicle. The appellants were informed of the accident soon after it occurred. They went to hospital, and the boy was seen in the ambulance. And as he was rushed to the intensive care unit, and the parents stayed with their son during the 2 days he was on the life support machine and saw him when he was obviously grievously injured. When there was no significant improvement, the father bravely took upon himself the task of switching off the life machine. Both parents obviously suffered psychiatric injury and made a claim against the hospital. Their claim at first instance failed, and on appeal, it also failed. It failed on the basis that both parents had a dawning consciousness that they were going to lose their son, and the court declined to extend the notion of proximity to this elongated process. So you've got parents here, they were with their son over a course of 2 days, life machine was switched off, and the court described this as an elongated process, and there was a dawning consciousness by the parents that they were going to lose their son. So the notion of immediate aftermath from these two cases has been put right back into the situation where it's a sudden horrific incident that has caused the onset of sudden nervous shock. However, a more flexible approach appears to have been taken in Atkinson in 2003, where the claimant's daughter was fatally injured in a car accident and she died shortly afterwards. The mother came upon the scene. She saw the police cordon at the scene of the accident, was told of her daughter's death, and later saw the injuries at the mortuary, and she herself, the mother, suffered a psychiatric reaction. Her appeal succeeded on the basis the aftermath could be seen to include more than one component. The test was as to proximity. So she was at a close proximity in terms of time and space to the actual accident. So whilst you have post-Alcock 93 and 94, where there is a much more of a restrictive approach that's been taken, in 2003, you've got this notion of a slightly more flexible approach being taken. And that's been carried on to a certain extent in terms of Taylor and Novo, but for the primary victim. So what happens if the primary victim dies 3 weeks later? So in Taylor and Novo, Cindy Taylor was negligently injured in an accident at work. And 3 weeks later, she unexpectedly died from a pulmonary embolism caused by the accident, and her daughter, Crystal Taylor, witnessed her mother's death and subsequently suffered PTSD. And she sought damages, so the daughter sought damages from Novo and succeeded in the first instance. On appeal, Novo argued that there was no proximity. Crystal Taylor was not present at the accident or at its immediate aftermath. Crystal Taylor argued that the death of her mother was the relevant event which she had witnessed, and therefore she had proximity. So Novo was saying there was no proximity because they were saying the accident was the incident, and Crystal Taylor wasn't there at the time of the accident, but Crystal Taylor argued that the death was the event, and she was there at the death and she'd witnessed that, and therefore she had the relevant proximity. The Court of Appeal then was subsequently led into this proximity discussion, and they decided that it was the accident, not the death, that was the relevant event. So if the death had occurred at work, then Crystal Taylor would not have been able to recover, and to recover later would not reflect what the ordinary reasonable person would regard as acceptable. And they cited Lordstein from White. Thus far and no further, Crystal Taylor's arguments would represent an extension of the law which should be left to Parliament. Think back about what was said in the very, very beginning in terms of the limiting factors for this area of tort. And one of those limiting factors was that any extension of psychiatric injury was an issue for Parliament. Taylor and Novo emphasised or re-emphasised the approach in Alcock and White, and went back to the restrictive approach that both of those cases had taken in terms of the limiting factors around proximity. Okay, so I'm going to leave it there. You can go and get another cup of tea or another break, and then when you come back, we will be finishing off psychiatric injury in the last section of this lecture.